But I haven't heard from the board, and we haven't heard from the board, and these are the board's rules, and I'm not at all trying to go around.
You're live.
What was this?
You're live.
You're right.
Yep.
I know.
I don't know if they,
I'm sorry. I've called the meeting to order.
There's a thumbs up from Kevin.
I forgot to give Kevin a thumbs up.
I gave
I'm
him
sorry. Thank you. What I'd like to do is not take a lot of people's time this evening, but I'd like to spend the first not more than maybe 20 minutes hearing from board members if they'd like to talk about their comments. And then, since the city attorney specifically requested time with us, maybe she can walk us through her memo. I have comments. I've quickly read her memo. Doesn't seem like anything too dramatic to me. There's one typo in it. So if that makes any sense, and if board members don't have any comments, we'll just go right into the city attorney's memo. But I'd like to hear from members. Should we get into a voting situation? Since Jane Begala is not here tonight, Andrew, I'm going to ask you to sit for her. Bill, you'll soon be coming on board as well for appointments for people who aren't here, but you're welcome to and should be participating as an alternate. So whoever would like to offer any comments.
Are we commenting on this, or are we commenting on the draft that's redlined?
The draft that's redlined first, just your general comments, because again, there hasn't been a feedback loop with the board. These are the board's rules, and there are important legal issues that the city attorney has brought to our attention, and that's excellent. But for example, I mean, you've been participating in meetings. Are there things that you'd like to see go differently, go more smoothly? Have I been doing things you don't
Yes, sir.
like?
Can I make a suggestion?
By all
Off
means.
of the city attorney's memo, simply because it makes more sense, and it's simply an opinion and not actually redlined and a change. Proposed changes in dispute, duties of the chair. Number one. That's ridiculous. Number one, the chair shouldn't approve the agenda. That's 100% completely ridiculous. If you pull out the books of Robert's rules, the chair approves the agenda. I recently, in the last 2 weeks, attended a planning board meeting in Kittery for my own business purposes. And at the very beginning of the meeting, the chair read and approved the agenda. It's Robert's rules. Why are we deviating from that?
Yeah, what?
and then it's,
Yes, Jim.
Mr. Mahana, then after the chair read the agenda, they voted on it,
Correct. The entire board voted on it.
and that's straight from Robert's rules?
Straight from Robert's rules. I have 2 copies in my bag.
I think the board, my understanding is the board can do however it wants. The only reason I had proposed that the chair approve it, and it's not an issue with, Peter and I do it, sometimes I don't even comment on it, but this isn't personalized. I just felt that there should be a person, whether it's staff or the chair, who does have the final say when it comes to being posted. So I think
But I'm reading the attorney's comments. It's unnecessary and adds a layer of review and is cumbersome. That's ridiculous. That's your job. So I would like the chair to have the ability to approve the agenda and set the agenda, for that matter.
Okay, if you say you agree or don't agree, let's keep it to that and not say it's ridiculous or crazy or, because
Next.
I'm probably as crazy as anybody here. So let's just say if you like it or approve it or not. So that's one comment.
Thank you.
Does everybody want time to actually read the memo? It looks like Corey
Well,
does.
4 pages, please.
Yeah, go ahead. Take your time, read the memo.
Sets the tone. I think what we all agree with is the planning. Chair, and that's good. Actually have them.
I think
I'll just read yours.
we have an extra one. the version that I made some changes to, and then I have the final version.
It's poor. It's- What he said is not inconsistent with what you have here. Oh, man, hot mic.
Folks about ready to dive back in, or need a few more minutes? Still reading, Corey?
A little bit. You can start the.
Okay,
It's fine.
it's a public meeting. Yes, Bill?
I don't know if it helps or hurts that I'm the new guy on the block, but I have written bylaws for half dozen other organizations that I've been in. And I've studied both the current bylaws or the proposed bylaws, and I'm taken by the state municipal association's recommendations. They have specific recommendations for the role of the chair, and I would think we wouldn't depart from those unless there was some real specific cause. The three that they mention should be delegated the responsibility to prepare the agenda for each meeting in consultation with the municipal staff and other board members. So it's not assist or whatever, it's to prepare. The chair could be delegated the responsibility to sign official correspondence for the public body. I think there's an element of that in here. And what I think is missing is the third one, represent the public body before other boards, commissions, and state agencies. I would think that we would want the chair to be the face of this group in representation with other city or state agencies.
Thank you. Anybody else? Greg?
I agree with what Bill said, and that's what's lacking in our current rules.
I support as well, and it provides precedence for what's happening in other city, towns, municipalities, and their organizations based on what's in Robert's rules. And
So now we have Robert's Rules and the New Hampshire Municipal Association supporting what I said.
Yeah, just so it's clear, we don't have to follow Robert's rules. That's an option.
Sure.
I mean, they've certainly been around a long time. So, you know, the board has a lot of discretion, including, and we'll get to it, but signing plans, that's something that the board can designate. I can tell you it's custom statewide that the chair signs plans. That's just
For the record, I agree.
As vice chair, I have signed plans.
Well, yeah, but the vice chair sits for the chair when the chair's not available. So you did it as chair.
So I would just say that I think, Mr. Bowman, is it?
Yes.
Yes. What you read from the Municipal Association is consistent with our practice in that the agenda is developed between staff and the chair. But there's no special provision for approval. Obviously, as part of that, generating the agenda, there's consultation with the staff, et cetera. The one concern that, and this is not strictly a legal concern, but a concern is that sometimes the agenda has additions at the last minute, and it adds an extra burden on the staff to need to go back to the chair at the last minute if there are changes. That's the reason that I raised that concern.
I think I'd like to point out that the staff works for the chair.
I don't think I'm done
Greg.
talking.
Not making any sense.
So, that was the reason for just putting in the concern for the suggestion of the additional requirement that the chair officially approve the agenda.
Susan,
So
I don't
that's
think,
for-
I doubt anybody's listening, but could you pull your microphone just a little bit closer?
Oh, sure. Sure.
So that's an administrative efficiency reason rather than a legal reason?
Right. Right.
I think the law should override efficiency, and if we need additional staff to help the planning department meet the chair's requirements, I think that's where the money should be spent. And what was just said makes absolutely no sense whatsoever. And if you read the charter and everything else, planning staff works for planning board. Planning chair is the head of planning board.
Mr. Chair, the planning staff works for the city manager, and I'm part of the review of the agenda as well. So it's a collaborative effort, I would
My
like to
comments
say.
are still the same. Thank you.
Sure they are.
I don't, the intent wasn't to make this into a big deal on the agenda, because it's not. As I said earlier, it's just, I think there should be, in the event of a conflict, that this happened, and we'll get into the details, it happened a couple of times within the last year. I resolved it without folks even knowing how it was resolved. And that's a workaround. It took a little extra time with the board to do it. That shouldn't be necessary. And, it's like having, there ought to be somebody, if it's not the chair, then it should say, I think that the staff controls the agenda. It should be one or the other. I think there should be a definition that, it is the final say, or, I guess those are the two options. Yes, Joe.
I'm just having a hard time understanding what's broken here. I know that as the chair, you have multiple opportunities to review the agenda long before it's published. You do already. When I was the chairman of the HCC, I was on the HCC for 10 years, and I was chair for a bulk of that. The last thing I wanted was to be involved in establishing the agenda. It's a massive task. It has to be advertised. It's a huge task that staff has to do. If there's a problem with the agenda, they reach out to the chairman. Sometimes it has to be split. Sometimes it has to be rearranged. But to have that as a responsibility of the chair would be, I think, very cumbersome myself. But I'm still having difficulty understanding what is broken right now. I don't understand what's broken.
The only thing that was broken was the instance that I mentioned where there was a conflict. And it wasn't even with, anyway, there was a conflict. I'm not going to get into it. It was conflict. It was unnecessary. And there was a dispute over who had control over the agenda. And I think whether it's me, and like our approvals that we do with every meeting, when we approve a project, it's not personal to the owner of the property. It runs with the land.
Right.
Whatever the responsibilities this board decides of the chair aren't, I happen to sit there now, but it's going to be somebody else again and
Right.
other people over time. So it's certainly not anything personal. If I'm doing something wrong, tell me that. I want to hear it. But that was the broken part, Joe. Just there's a conflict of, in fact, I said, well, I think I have final say in the agenda, and the response was, no, you don't. And so it caused a little bit of a hiccup. And it's only happened twice in 2 years, so, and that was back to back. That's correct.
Final comment, if I may quote. Under Robert's rules, the agenda is initially written up by the secretary and approved by the, presiding officer or chairperson, options. However, the adoption of the agenda for each meeting should be, back and forth, voted by the majority of the assembly at the beginning of the meeting and only at the point it is binding. So that gives multiple. So it talks about presiding officer or chairperson. That's the choices. And then there's also, at the beginning of the meeting, the option for somebody to have a problem other than the chair. So it's not 100% the chair, as Joe's or the city attorney is trying to assert. There are two backstops there written right into Robert's rules.
That's one way to do it. So, that would add a layer at the beginning of the agenda. We would adopt the agenda. So that would be another thing that the board could do. Practically speaking, on a day-to-day basis, especially the way things have been going the last 6 or 8 months or whatever, staff's going to prepare the agenda. If they have a question, they'll ask. It's just in the event of a disagreement, who gets to make that decision. In the event of a disagreement that gets to Karen's desk on a city matter, we know where that decision, it stops at her desk. So it's a similar thing to that. I don't know how often that happens, probably more often than it might happen with what we're talking about. So,
Is this as simple as at the beginning of the meeting, if I'm understanding what you're reading, Greg, we're all saying that we agree with the structure of the agenda after it's passed through all of these other filters, and then we officially accept the agenda at the beginning of the meeting?
Or change it. Correct. I mean, I literally just witnessed it 2 weeks ago in Kittery.
Of course, the agenda is advertised, right?
but it's advertised noting that it might change.
Correct.
Right, what's advertised is just the things for public hearing. I mean, the agenda has other items on it.
And people
That-
come here specifically to speak to the agenda, the public does sometimes. I mean, there's some complications that could arise, obviously.
But I'm following the procedure that council does all the time, and the motion to suspend the rules and move things around for the benefit of 12-year-olds that are here at 7 o'clock that don't want to be here at 11 o'clock. It provides a level of flexibility to knock small things off early, whether it be, how we do motions to continue or extend, depending on whatever it is. We can put those at the front, toss them, and then move on to the meat and potatoes of the meeting.
It also, there's an opportunity to abuse that privilege too, if people just want to move things around because certain things are contentious and others are not.
Well, honestly, we have to vote on it. So it's like council does it. Somebody makes a motion to suspend the rules and move the children's baseball field up to the beginning so that they can go home and go to bed. And that's prudent, makes sense. It's mechanically correct, and it has to be voted on. It can't be abused if it has to be voted on.
Beth?
This doesn't
For an example, we never used to approve for completeness site plans or subdivision. That was never part of our agenda when I first joined the planning board, now almost 10 years ago. That changed when we had some questions as a board, and that's why now we, as a board, vote on that, because previously it was just the planning director who would call that complete. So I sort of see this as a change that evolves around this, around the same similar type situation. We were trying to take off of the planning director at that time the fact that they would then get blamed if somebody complained they didn't think things were complete. And we figured if us as a whole board voted on it, then it would feel complete. I don't see a problem with keeping the rules the way they are, but then adding that to the agenda that then can be a discussion of the board in the public forum. And then that would have to be a majority of everyone that wants to make that change. And we have in the past moved up everything that was going to postpone and done them at the front part of the meeting. So that's been done before. It's absolutely possible to do now. We we suspend the rules to hear things together. We suspend the rules, for other things. So there's no reason why it can't be done. If making everyone happy is just adding it as one more approval like we do with subdivisions and everything else, then I think it's probably better it comes from the whole board versus just one person. like
So,
you said.
so it wouldn't be suspending the rules, it'd be writing the rules in that regard, so that would be a part of the rules. So do folks feel comfortable with that, that at the beginning of the meeting, the board would adopt the agenda? Does that make sense to do it that way?
I think so. And at that time, you would suggest if we wanted to move things up
Right.
or back or
Right.
continue them. Yeah, that makes entire sense.
Yes, Mr. Chair.
I like that.
That's why it's in here, I think.
Guidance only,
Okay.
it's not a Bible, it's guidance.
Most of the civilized world meetings use Robert's rules, so it's obviously an established procedure.
Does the city attorney have a problem with that? Does that seem like a,
There's nothing in my suggestion that prevents the board from making a final approval, or even without some formal approval at the beginning of meeting, you're free to, whenever, suspend your rules and adjust your agenda as you want to. That's done routinely, so there's nothing in the suggestion that I've made here that prevents you from doing that. There's nothing that changes the process of the consultation with the chair.
Right.
My only concern was for, potential conflicts with the staff and timing of getting the notices out to be published in time, and having to find somebody to get a final approval. I think probably in the process of developing your agenda, there isn't going to be any need for any additional approval because you will have agreed to
No,
the
this-
agenda.
yeah, this, excuse me, I'm sorry, did you want to continue? I didn't mean
I
to.
just wanted to say that I think that the process, as you said, at least in the last many months, has gone very smoothly without any formal rule that says you need to give final approval. And I was just trying to avoid any additional burden of that. But there's nothing here that prevents you or the board from approving the agenda at the beginning of your meeting or suspending your rules and changing the order of items.
Oh, so to be clear, it would be a matter of formally adopting the agenda at the beginning of the meeting. That would just be the first item on the agenda at each meeting. And that would not be suspending anything. That would just be a part of the regular proceeding. And in terms of getting it to that point, we work it out. So, like, to your point, it's not broken, let's keep
I
doing
just
it.
wouldn't want it to be common practice to every meeting we're shifting the agenda around all over the place. If it's a once in a while thing because it makes sense because there's 12-year-olds that need to put it, fine.
Right.
But if we are every meeting reconsidering the order of the agenda, that's
Then it is
cumbersome.
broken.
Right.
So if I can just say that in section D, general order of proceedings, it says, at each regular meeting, the following agenda format shall be followed unless otherwise modified by the board. So I think you already have that option to change the
Except-
order of how things happen.
Number one would be to adopt the
Right,
agenda.
so we could just,
So, that was easy.
But does that speak to the preparation of the agenda as well? Because I can't imagine you want to be part of preparing the agenda.
No, we're
but-
just going to do that in the background. We'll work it out. I don't think it needs to be, let's not raise it higher than it needs to be raised. This is a good solution. Better than what I wrote. I like it.
Could I just ask, Peter, you would notice, I know that it used to be the order of the agenda historically and for Historic District Commission was when the applications were received.
yeah, they're
Is that-
time-stamped. For the new applications, they're time-stamped, so,
So whoever gets there, gets
Yep.
in line first, he gets the benefit of
Right.
potentially, yeah.
Except occasionally, and we will talk about this, there's going to be a few things that we might want to move up at the beginning.
Right. Large meetings, very short, yeah.
Troublesome.
But as
Elderly
practiced
folks.
unofficially or officially, I don't know, the order in which you receive the applications, you typically like to stack them that way initially, or?
right, when
Okay.
the order they are received in, they're time-stamped, and that, for
Okay.
all boards, that's how it
Okay.
happens.
Great.
But when we talk about, and we have a pre-meeting the Tuesday before the planning board meeting, and the manager sits in, and as you know, you sit there too, and we go over things, and if it looks like something's going to be a problem, we might consider suggesting moving it around
Right.
for that reason.
And we have.
Yeah, and we do, so, okay. If we go on to page 2, number 2, as I mentioned earlier, actually it's 67437, not 67937, and the statute basically says the planning board can say who signs plans. It's customary in this state that the chair does it, and the vice chair in the chair's absence. So if you guys want to have it, any board member, that would be unlike any other planning board I'm aware of, but you can do that.
Can I just say, from a title perspective, you might have a few attorneys curling up, and because we always look for the authoritative head of the board to sign off on any plan that I look at when I'm doing a title search. That's what one of the many things I'm looking for is that signature and authority. So it might be difficult otherwise.
And that's usually, it's pre-printed on many engineering and surveying plans, you know, the chair of the board, so that's just custom. It could be either way, but that is the custom, so.
So the question is just whether you want to allow for the chair or a designee to sign that. Some other member of the board could sign the plans in the chair's absence, and whether you want that clearly stated in your rules is up to you.
I think it should be the chair or the vice chair. I think that's, you know,
I agree.
those are the best point as well. I mean, it would be unusual to have a planning board member. That would send somebody searching for these rules to find out if they had that authorization, I think.
I'm good with that. I'm good with that.
That make sense? Just have it that way, chair, vice chair.
Yes, please.
Number 3, there was no desire for me or any other chair to spend city funds without council approval. It was just the difference between, can that approval pre-exist that signature? The way I read what had been written required going back to council afterward. That's why I limited it just saying what, in accordance with applicable city code.
It's just a difference in language and whether you need it. It's specifically right now, it
It's a-
requires city council approval, which is what the city code says, so it's just a matter of style. I think it's clearer to leave it the way it is.
My intent was, I think the only thing that I can think of that the planning board and the chair would be acting through under the authority of the request of the planning board would be the master plan. That'd be the only thing I can think that that's the only item that the planning board has statutory authority over that the council doesn't, but the council has to appropriate and budget the money. Once budgeted and voted and adopted, I think the planning board can engage consultants to carry out the master plan, the way I read the statute. That'd be the only thing I can think of.
Yeah, I'm not suggesting that you can't. I'm just suggesting that the language in the rule be specific as opposed to more general, where you put applicable city code versus the approval of the city council.
Greg?
Question, possible scenario. We have the third-party consultant situation a lot, particularly when we don't have an expertise. And, you know, sometimes we ask the applicant to do the third-party consultant, but there would also be situations where I would think that a land use board would be interested in doing that. And I think it would be overly cumbersome to follow what the city attorney says, that you got to go out to council to spend $3,000 or $4,000, whatever the number is, to hire a third-party consultant to clear up a matter that is under a land use board, which I think your intent here would expedite that and move the process along.
I think it's two different things. What you're speaking about, there's a statute on that. The applicant has to pay for that,
Always?
always.
Okay.
And the
Okay.
applicant has
Thank
to
you.
approve, the applicant has to approve that particular budget and that consultant.
Okay.
It used to be that the planning board could say, you have to hire Jim Hewitt, not as a planning board member, let's say he wasn't a planning board member, and, you know, whatever he wants to charge, you have to pay it. Well, they can't do that anymore,
I see.
thankfully. So the planning board might say, we think you need to hire Ty and Bond. And if the applicant has a problem with that, it's a negotiation. But that's money paid directly from them. What this contemplates is city funds that the planning board has approved, that the council has approved and the planning board would be spending. And as I said, the only instance I can think of is a master plan. That would,
And when we were on CIP, you and I both, that was the intent of when we talked to city staff, adding additional funds because it would seem to be a little light in current economic conditions to find an adequate consultant to build us a quality master plan.
honestly, this is somewhat symbolic. If people have a problem with this, let's move on. If you want to do it, let's adopt it. It takes 6 people in concurrence to change any of these rules. So, you know, this isn't a hill to die on as far as I'm concerned.
I think it's fine the way it is, myself.
The way it is being the way the city attorney had written it.
Mhm.
Are folks good with that? Any objections to that?
I still like what you wrote. You know, I don't know how we're doing these line by line, vote by vote, opinion by opinion. I mean,
Well, I'm looking around the room to see if we need a vote. We didn't on the agenda issue. This one we might. Yes, Mark?
My only question would be is, and I'm just I don't know how this process works. So how does the contractual process work in the city? So even if we were to say we want to go with XYZ consultant to do our master plan, I mean, the contract still has to be bound and signed, so.
There would still be the requirements, the contractual requirements the city would have to sign, but this would add a signature from the chair. That's all.
Mr. Chairman, I can answer that question very specifically. We have a form for a 3-party agreement. And basically what the 3-party agreement, and the 3 parties being the city, the developer, and the consultant or engineer, the 3-party agreement says basically that the contractor, engineer, consultant will perform work as the client of the city, so that there's no question of to whom loyalties are owed, but that the developer will pay the bills. The bills are presented in duplicate to the city and the developer at the same time. Developer pays the bill, provides the city with notice that the city's consultant has been paid, and proceeds like that. The duty of loyalty is owed to the city, but the contractual documents produced under the 3-party agreement are available to all 3 parties. So
I don't,
that's the
was that what you were
contractual.
asking?
Yeah, well, it's just, as someone who has to deal with this on the governor and council level, there's
Daily.
a lot of hoops you have
Daily.
to go through. So I just wanted to make sure, it's not as cut and dry.
Here's as somebody who has been hired to do master plans in other municipalities, it is nice to work with your clients, who is, in this case would be the planning board, have the planning board say you've been hired, have a formality in terms of a signature, and then if it has to go and get signed by council and the other things in the legal department, which it does as a legal contract, that's separate, but it forms the allegiance between the consulting team and the planning board, and that's super important in a master plan process. It's the number one, if you read the statute, it's our number one responsibility, and from that, everything else flows, the capital improvements plan, zoning, everything.
No, I totally agree. I think we should be selecting the consultant that we want to work with, because we are but I just want to make sure, legally and contractually that the process is playing out as it should.
That's why I had it broad, applicable city code, so it wasn't limited.
so there's all those stop gaps behind it.
Right.
Well, there's a procurement process that has to happen, that
Right.
the city doesn't stray from on any contracts at all.
That's
so.
that's the second step
Right.
that I said,
Right.
yeah. And Susan, you had,
So, I'm not sure that we're all talking about the same thing. So I don't think there's any disagreement that the city council has to authorize
correct,
the expenditure of funds.
right.
So I don't know exactly what the disagreement is at this point.
It's a question of wording, the way I read it, well, like tonight, the way I understand it, the master plan has been budgeted. We have, as I recall, 250 this year and 150 possible next year, something like that, whatever the numbers are. It's been appropriated, it's gone through the capital improvements plan. We are not going to adopt a consultant tonight because we don't have any idea, but if we had a consultant who had gone through a process of selection that will involve staff, by the way, and we're ready to hire XYZ firm, and that principal comes to this meeting, we've voted to hire that person, at that meeting, there could be a signature. Somewhat of a formality, except if it's in our rules, it's not a formality, so that they know they've been engaged. Now, the legal steps to actually get them paid, take them upstairs.
Right. So the way that you have this written,
Mm-hmm.
that you would sign the agreements with the consultants after a majority vote of the planning board granting such authority and in accordance with applicable city code, which is the approval of the city council. So, right? So those things would happen after the approvals.
Or, in my example, has it already happened? I mean, hasn't it, by virtue of being a part of the adopted agenda, hasn't it already happened?
No. We have to actually vote. City council has to. So, use a recent, we get agreements all the time. We recently negotiated agreement regarding sewer fees with another town, right? We give authority to the city manager to negotiate and sign things. And we give the authority on what money to spend. So all of those steps would have to happen before an agreement's actually signed, in my mind.
Okay, so
Even though something's budgeted, it doesn't mean it's spent until we actually vote to spend it.
yeah, the master plan is an interesting thing, because the council has nothing to do with the master plan under the statute.
Except pay the bill.
Right. So I'm wondering, and picking up on what Susan has said, maybe the only way that this could happen appropriately with the scenario that I'm envisioning is that we get authority from the council before that signature event with the consultants.
Right.
And say, we're probably going to hire XYZ firm
For a certain amount.
with a certain amount, and that could be happening next month. Do we have authority? Will you authorize me to sign?
Correct.
Then we're all good, right?
Right, and I think that's really what you've written here. It's just that I wrote it out longhand with the approval of the city council, so there wouldn't be any confusion. I think that's the way you wrote it already. That it
That's
would
the
be-
intent. That was the intent.
Yeah.
I'd be more comfortable with that because the way you described it earlier, you were giving a notice of intent or a notice to proceed without,
Authority.
Let's change it the way I just said. I'll seek approval from the board. If you grant me approval, I'll go to council, picking up on what Bill said about representing the board, seek authority from the council. If the council gives authority, then we'll be armed at a meeting to actually hire the consultant. Does that make
Right.
sense?
Yep.
That makes sense.
That makes more
Okay.
sense.
Better?
Done. Solution.
It's all good.
Okay.
Okay.
Sorry.
That's in front of these notes, right?
Thank goodness it's being recorded.
On the quorum things, and I'm just going to follow through with the city attorney's memo because it seems like we're happy to do that. the remote participation thing, this came up, and I read what the Municipal Association had in another publication that I don't think I shared, unfortunately, because I've been too busy. They suggested strongly, and that's why I added all these provisions after the last time I sat with Susan. It wasn't meant to decide,
So I just
Sure.
went back and read the statute. So
Mm-hmm.
I'm citing the language of the statute, and, as all legal analysis, you're safer to stick with the language of the statute than to veer off.
I understand that, and believe me, I do my best to adhere to the laws. It came up at a meeting. The planning board actually wanted the chair to have discretion about this, and so I put it in there for discussion. I don't know if you recall, I don't remember who couldn't attend. Oh, yeah, it was you.
Troublemaker.
So.
He's got to do it.
It was in for discussion. The board, but in any case, however you want to do it, and the way we did it that night, the board is supposed to make the decision about whether to allow remote participation.
Right, exactly.
That's the way
Yes.
it's supposed to work. Now, folks weren't happy with that night. And so again, I just put it in this way as an addition, and that one little clause about with the discretion this year, whatever I wrote, that could just come out. Yes, Beth?
I think this should only be the case if there are no alternates available to sit in their place. Because why do you have alternates to your board that you've trained, that you keep there, that participate, and not give them the opportunity when they're there in person to vote? So if you have no alternates or there's just no one to fill in, then this should go to a vote of the board as to whether or not they want to make their night longer.
Mr. Chairman, Ms. Moreau recalls that night where we did have two alternates available, and I think that was the frustration of people not understanding why we couldn't recognize the voting ability of those two alternates.
If I could, that's exactly why I was in the same camp, because I always want to exercise the alternates who sit there, and for that reason only, I also voted to not allow that, because we had alternates sitting right there. That was the only reason.
I guess my comment would be then, why do we allow city councilors to participate remotely?
We don't have alternates.
Point by you, but you can still have a quorum.
I think there's arguments both ways. I think that night you really, really wanted to participate, as I recall.
My point was that I prepared for it, and I travel for a living, and I'm 4 days in a hotel room. I'm not incapacitated. I'm not in bed. I'm not in a hospital, and I don't have a broken leg or a wired jaw. And so as we learned throughout the pandemic, remote participation was not only allowed, but it was encouraged if you were available remotely. If I'm quarantined in my house because my wife has COVID and I don't want to bring it here, and I can sit in my office at my house and participate and do my duties, my other concern was because I travel for a living and I did miss a few meetings, and I didn't want that going against my record as, okay, that's your third meeting you've missed in 6 months. I mean, we do have a rule in our rules that says if you have excessive absences, you can be relieved of your duties. And so my goal right there was, I'm in a hotel room, bored out of my mind. No offense, it's not just fun being on the road. I was perfectly able to spend my 3 or 4 hours on my computer and participate to the duties that I signed up for and was appointed to do.
Peter?
And in that case, the alternate didn't have equipment and have background or preparation for that night, I believe.
I think Andrew was there.
I think it was two.
I think we needed both
Had
alternates.
both of them there.
Andrew was already participating, I think.
Yeah, he was.
It was Ernie Carrier, I think, was there. And
Mr. Chairman, would it be helpful to hear from legal about when there were emergency provisions during the pandemic that related to remote participation and how those changed when the pandemic declaration was over?
Well, I don't think the state law really anticipated remote participation until the pandemic, really. And that's where the statute and the revisions to the Right to Know statute came in. There's nothing to prevent you to vote on whether you want your member to participate remotely, or have your alternates participate in absence of that person. That's up to the board, and that's still part of your rules. My only point here is that you need to carefully follow the language of the statute, which still says it's up to the board by majority vote, if you make a finding that it's reasonably necessary. That's the standard that you have to apply.
And that ties directly into the alternate question. So I think we have only two issues here. One is, if there's one way to do it, if you have alternates present, they would first sit. That's one way to do it, and not allow remote participation. The other is, if a member really wants to participate, does it come to a vote of the board? That's the two ways to do it. So, and take the chair right out of it. It's a board decision. So those are the two things. It's either
think
use
it's
the
the very-
alternates.
I think that's the very purpose of having an alternate myself.
I understand. And I think you made that point well.
Yeah.
And so is Beth. So the way I read the current rules, we can't adopt anything tonight because we weren't specific as to what but we can have a consensus. And on this particular point, how do people feel that would be the way to go, to use alternates as opposed to remote participation?
At least first. I think you could have remote participation as an option when there isn't an available alternate.
In the case with Greg, where if he's redlining because he's missed a few meetings and we realize that and he needs to participate, then we would consider that, and but to make it a rule that alternates are passed over, I think would be a mistake. But I don't think we'd ever use I would hope that we would never use this to out someone because they were on the road.
Well, we could word it such that a regular member could request a vote of the board. You could put that in as a
Right.
request.
Right.
So that if they make that request, you vote it. Otherwise, you use an alternate.
That's
that work?
That's a reasonable approach right there. Thank you. I mean, that gives it a little discretion.
Does that work?
Yes.
Yes.
No?
Not for me, sorry.
Not for you.
I think one thing to consider in, deliberating on your rules is that, the point of the right to know law is generally to have people present in the public, to have that face-to-face confrontation. And as the city manager pointed out, this only changed as a result of the pandemic, where it was really necessary to do this and to make accommodations for everyone during the pandemic. And now the state law is allowing this to continue, but only when reasonably necessary. So your vote as a board, whether you state it specifically or not, would be determining whether you think, if you have an alternate present, is it reasonably necessary for that person to appear remotely? And that would be on a case-by-case basis
Right.
for the board.
And I think that's what we just said. So I think we're good, not unanimous, but we think it might work.
I
And
would
if-
need to see the language.
Sure, you're not voting yet. Peter and Susan and I can figure that out. We might even ask Bob to weigh in. On that same point, the chat function with Zoom, this did come from the Municipal Association and made me think about it. My thought was to let people know by Zoom that your chat is not going to be a part of the record. If you want to be a part of the record, you have to speak. Because if you allow the chat function, then it has to be read into the record from what I read.
I'm
That's-
not sure I even understand what chat function is.
If you're, okay,
You're correct.
if you're on
So,
Zoom. if
I know you're on Zoom, then you're speaking, and that would go into the
No,
record.
There is a chat function
type
between
Where
the
you're
members.
simply
You type a
typing.
question,
To anybody on the
We do it
meeting.
on webinars all
I'm
the
pretty sure
time.
it's disabled in our public meetings
Oh, Chast's
Correct.
disabled?
Good.
Yeah,
on the
so they
Zoom.
can't use it.
But I think it'd probably be a good idea just to tell people not even to try, because
Chat is disabled.
it's, you can also, I can just chat to you or to the group, and it's not anything, it's not consistent with the right to know law, I don't think.
It's a
No.
distraction, too.
So that was the only thought on that. It was just, it seemed to me like it was a good catch by the Municipal Association to even bring it up, because I hadn't even thought about it.
Yeah, that you wouldn't even allow it, because, I mean, I've been in other conversations with other boards about whether board members should be or shouldn't be, more precisely, texting each other during a meeting. So again, with the right to know law, it's all designed for the public to hear all of the deliberations and all of the information the board is considering.
In that regard, for what you just mentioned, and if we did this would have to be an exclusion for this manager sitting to my right. Texting during meetings is not permitted among members. That's clearly excluded by the right to know law. I think it's,
In regards to the deliberations, or
Right.
what's going on, yeah.
You just
But-
said it was excluded. Can you repeat
you're not allowed to text, I'm not allowed to text you, hey, I think this is a pretty good application.
Amongst
What
the
do you
members.
think?
Right.
You know, that, you can't do
That
that.
have to do with me,
That's
though.
understood.
Oh, that's what I'm leading into. I'm leading, don't get nervous yet.
Don't get nervous yet.
I've heard, well, I've heard from several members that they don't like people texting during meetings. You have to text during meetings. That's
I
why
had to take a call from the police just now, that's why I left. So
That's why
I hope everyone would understand that.
Fully.
I do, and that's why
Fully
I
understood.
teed it up that way. I wasn't trying to.
She has duties that outweigh
Exactly,
her sitting.
exactly.
No doubt. No doubt.
I would argue that I need to text as well for facilities, there's things happening at night and so forth that I need to know.
Okay, so we shouldn't have a no-text function, or we should have a no-text function?
What I'm saying is you shouldn't be texting about the subject of the meeting.
Can't do that.
Right.
That's
We already
against
can't
the
do that.
law.
But it's, okay, I have no problem when city employees have city issues and they need to text and walk away, right? That's all good. My issue is regular members texting when you don't know who they're texting to. It looks bad to the public. So for the public to see members of this board sitting here on their phones doing something and they don't know what they're doing, it could get that applicants could start to complain and bring that up. So, and it's distracting to other people near you as well. So I think
However, as a volunteer, a board member and a business owner, you know, the business is on fire, your kid is in the hospital, your wife got hit by a car. I call
I'm not
BS.
saying things don't happen, but when this
But you
happens
can't
on a
say-
regular
You can't say no
basis,
texting, is my point.
I think you can say it unless there's an emergency.
Now you have to define
I
emergency.
would think as adults, we could police this issue.
Exactly,
Agreed.
exactly. It doesn't need
Yeah.
a rule.
The key is that you
Okay, I
can't-
raised
members
it, I
can't
was asked
text
to
each
raise it,
other.
done.
Thank you.
Now, I promised the manager we'd try to be out of here by 7.
You have about 30 seconds.
Have one couple.
Aye.
The rehearing, this is kind of an important one, and Bob, I think you had suggested this at one of our meetings. Do you feel, I think we should have the provision. Are you comfortable with this? the way
We've
you-
had a lot of discussions on, and we changed the language to reconsideration rather than a rehearing. After
That-
looking
Yeah, I
at,
like that.
looking at the law that's developing, and it is still developing. But that you clearly have the authority as a board to reconsider your own decision as long as it's within the 30-day appeal period. But to have a formal rehearing is not provided for in the statutes. And as the law in New Hampshire is, if it's not, doesn't say you can do it, then you can't, you know, if you're not authorized to do it. But some of the case law is that you have an inherent authority to reconsider your own decisions, and that's probably a good thing, because sometimes you make a mistake and you want to fix it before we end up in litigation.
It's like
So
buyer's
that was
remorse.
the kind of compromise as to the language here that we worked on as a
I like
team?
what you've done with it. I think it's helpful. It's helpful to applicants. It's helpful to,
I
you know.
agree, we can make a mistake, and if legal tells us you messed up on that vote, we should be able to give the applicant the benefit of the
It
doubt. of
allows
their mistake.
people, it allows something to be fixed without having to go to court. Yes,
Perfect.
Andrew.
Just a clerical question about how notice would work for that. What is the
Good point.
window of notice for rehearing or public notice or butters notice?
Consideration.
It probably wouldn't be. You'd probably call a special meeting
Right.
because it has to be within 30 days, and then you would,
So you would have to go through the normal notification criteria to.
Well, the
advertise
way this
the
is
meeting.
worded, though, you file it within 30 days, but then it comes up at the next regular meeting. So it would go on the agenda for the next regular meeting, so it would be noticed that way.
To then
And
be
I like that, too. I like the way you did that.
Well, there's problems with that you might have to work out, practical problems, depending upon when your next regular meeting would be, because you also have to stay within the 30 days. So they may not always be within 30 days, so you might have to change that to at its next,
Earliest convenience or something
yeah,
weird like that.
right, something like that.
Should we say upon filing of a motion, because it can be filed with the city? And I think this came up in one of our applications, just because the planning board doesn't meet every day.
Right.
And we're not here to receive a motion, but the staff is. And if should we just say that, upon receipt of a motion filed with the staff for reconsideration? If that's filed within 30 days, then the planning board takes it up at the next regular meeting?
That is what this says.
Well, I
So,
added with
yeah,
staff.
without voting, we could clean that language up so it's clearer that you're going to consider any motion or request for reconsideration within your 30-day time frame. However, that has to occur, whether it's a special meeting or a regular meeting. You don't have to take a vote to reconsider. You can just have a reconsideration.
Here's my question, if this worked, I don't know if this works legally. Let's say the two planning board meetings are 34 days apart, and somebody files a motion for rehearing the day after the bad decision they don't like. If that's accepted, can that then toll or stay the 30-day, the actual planning board vote has to be within 30 days, so it has to be a special meeting?
That's the way the law is developing so far, is that
So it can't
because
be,
you
it
don't.
actually can't be the way you worded it then. We can't have it at a regular
Right,
meeting.
it needs to be, probably needs to be worked on a little bit, but the idea here was to change this to reflect the fact that you could reconsider your own decision, as opposed to having like a formal rehearing like the zoning board does. But you could
Right.
reconsider your own decision, but it has to be within 30 days of your decision.
And is there a provision to call a unscheduled special meeting for us? Yes, right?
Chair can do that.
Yeah. Just for that matter, I mean, you could come in and knock it off.
And we just have to legally notice it
We'd have to
correctly.
legally notice it, come in and knock
Right.
it off, knowing
Right.
that we have one thing on that particular meeting
Right.
agenda.
Yes.
I just want to make sure that when we rewrite this, it's clear. You say upon our decision. Should it be upon our, so 30 days, when does that start tolling? Does it toll the night we take the vote?
Yeah.
Does it toll at some other date after that? So I just want to make sure it's clear when it's
It
written.
would be the night of your vote,
Oh.
just like all the other appellate,
Yeah.
appeal periods.
So I'll keep going as long as you want. Or do we want to, I think there's work to be done, what I'm hearing, not.
I think she has the intent accurately, so if she
Oh,
can
I think,
wordsmith
yeah, I
it
think
into something.
it's good. It's
yeah.
just a little wordsmithing.
Yeah.
So I think the only other concern was, and maybe we read this wrong, but it looked like in your edits that the time and order of rounds for public comment
All right.
was at the discretion of the chair, as opposed to, and that seemed to be in conflict with the remainder of the rule that set forth, specific 3 minutes, 10 minutes, 10 minutes. So,
It used to be 3 minutes, 5 minutes. 3 minutes, 10 minutes, unlimited.
Yeah, as you notice, we haven't been doing that, and so I was trying to write what we've been doing. I found it somewhat constraining to have to do that, and that's why I said, at the discretion of the chair. It's a board decision, it's what you guys want to do. I mean, the other way of doing it, if you have a fixed 3 rounds, is I would ask every meeting, every time, for 3 rounds.
And then you have to ask for the second and third, and if nobody's there, you just move on.
If no one comes up for first round, I don't see a reason to have a second or third round, and I think we could write that into the rules that way. You have to come up for first round if you
Want to
plan on.
speak at second or third.
As
Correct.
long as there's something in place when we receive our next very contentious application, and this room is packed, and we have a line of people at the podium, we've all seen that.
Yep.
And they all cannot speak for half an hour. They just can't. They can't.
And that was-
That's part of the intent, I think.
Right?
It's when we started doing this. I was actually here when we started doing this
Yeah.
because first-time speakers would come up and speak for 20 minutes, and
Right.
other people that were in the back of the room that wanted to speak got frustrated.
Right.
And so and we said we were specifically doing it this way so that everyone at least got a chance for a few minutes.
Right.
And then, once everyone goes through, then those people that want to talk longer can come up and have that opportunity. And I thought by law we couldn't restrict the time in the end, which is why unlimited was on the last one.
It doesn't say that, though.
It doesn't? That's what I think I heard back then. But I mean, if I'm wrong, I'm wrong. But yeah, and trust me, I've always found that even people who speak for a full 10 minutes in fairly complex things come up and probably don't speak for less than 5 minutes at the last part. I've never had anyone.
Is that a
Just
tool
stand-
that can be available in the event that we have a packed house, or does it have to be the same every?
Well, that's why I was
single time?
saying if the first round nobody comes up,
That's true, yeah.
then you
Yeah.
That's why
squash
I had
it.
discretion of the chair. You can, depending on how the agenda is and what's going on that night, if the room is full, there's a way to deal with it, and I can ask Karen to use the timer, and she does.
I think it's appropriate to have it the way it's laid out, change it to unlimited on, so we'd have to change that third one. The reason I say that is, the last thing you want to do as chair on the night that the room is packed is think about, okay, how am I going to set
How
up
am
the
I gonna
public
limit you
hearing?
all?
If it's laid out from the get-go and it's the same for every meeting, people are going to understand, all right, I've got my sheet for my 3 minutes, I've got my sheet for my 10 minutes.
Or whatever,
Yeah. At least, yes, it does, you have when the room is empty, you say first round, second round, third round, but
How about just some language to address that one thing, because that's most of our meetings.
Right.
So if it's in the discretion of the chair, if there's nobody who comes up the first, there's no need to go the second and third
Yeah.
round.
Correct.
Something like that.
yeah.
Yeah.
So,
I think that's a good change.
So we agree on the intent.
yep.
Susan, do you know how to write that?
So I just want to point out that the legal concern is, due process and fairness, right? So it shouldn't change from meeting to meeting. So anybody who comes should know any planning board meeting, I can speak
gonna
for
happen.
3 minutes and then 5 minutes and then 5 minutes or whatever that you can decide what that time is and put it in your rules.
I mean,
And then clearly, if there's no one there, you
And
don't
it-
have to.
And exactly what Beth said, if nobody comes up for the first round,
Yeah.
then there need not be a second or third round.
Correct. And I think that should be clear so that people know ahead of time that if they
gotta
want to
get up.
speak longer, they need to get up off their duff and come up and tell
The
us.
second time.
So
yes.
do you want it to read that only those who speak in the first round would then have a second round?
Yes.
Is that
Oh,
the way you want it?
Yes, absolutely. Yeah.
And that same thing applies when someone is participating remotely?
Well, they
Yeah.
have to put their hand up online too, so yeah,
Yeah, it's kind of,
same thing.
So even with the unlimited,
There's no unlimited, that's a mistake.
We can,
third
we
round
can
is
do
10
3,
minutes,
5,
right?
10. Do
I'm
3, 5, 10.
trying to
3, 10,
prevent
10.
silliness.
Here's-
Right. Someone being silly,
Unlimited can create a filibuster.
right.
And,
Exactly.
and it's not in the rules, that's a mistake, that's like a legend. It's not, it's not in the rules.
unlimited.
And I would not support that at all, because you could get, I mean, I won't say who, we had an attorney get up one night, and the statement was made, I don't have anything to say, but I can't avoid an open microphone. And there was a
FX.
soliloquy for probably 10 minutes that had nothing to do with anything, really. So I want to avoid that
So
sort of
this
thing.
is a serious question. It's going to sound like a silly question, only because these silly things do happen. How are we preventing puppet shows and music being played in our meetings?
Is there a way to clarify that you can speak on the subject at hand rather than just, to what Joe just said, ramble? And what you said,
Yeah,
ramble.
no, it is because
That you need
this
to
is what
speak
exactly what,
to the issue.
The motion
we are
or the
limited. We don't have open
To,
mic.
for, or
Public
against.
comment.
Yeah, we don't have open mic.
Yeah.
You can't come here and talk about, a new constitution.
Well, I mean, when you ask for public comment, you say to, for, or against. Does that
Right.
Right.
keep that
Yes,
tight?
yes.
This is a
It
precedent.
has to be, you can write, you could put a few more words in there to make it, more specific or clearer to people who are reviewing your rules, but you are not opening this up to a public comment the way the city council or the school board does. You are having commentary on the
The items on
issue
the
at
agenda.
hand for the proposal in front of the board, and you shouldn't have to hear any soliloquies from anybody or puppet shows that are not relevant. So if
Right.
it becomes not relevant, then you're out of order, and the chair could rule you out of order.
Great.
Perfect.
And that can rise to the level of a crime if it gets too bad, as we have
Going
discussed.
through the steps, yes, yes, yes.
Yes, yes, yes.
So I certainly agree with the unlimited, we got to change that. Does anybody else feel like we should go to 5 minutes in the first round instead of 3? I feel like a lot of people get cut off with 3. I mean, it does drag it out that first round, but
When I was in here that one night for Harbor Corps from 7 p.m. till 1 a.m. with a room full of people, and that was only half the project, 3 minutes was more than enough
Yeah.
time for most people. So, yeah, sorry. I'd be a hardcore.
no, I mean, they can
three.
come back up. They can always come
They
back
can always
up.
come back
But
up,
I
and
just,
that's-
I know a lot of people just,
I know what you're saying.
I know you feel like you're
Hours of
cutting them
listening to
off
people.
Yeah.
with a buzzer, cutting them off with a buzzer, so.
Influence
can be
my
said
brain
in 3
forever.
A lot can be said in 3 minutes.
Yeah, if you're succinct and you know what you're going to say, you're going to
Prepared.
say
You're
it.
prepared, and you're
Yeah.
speaking to
The
the
one thing would
subject
be
intelligently.
to be consistent with the other boards and council and things like
Right.
that. So if they're doing 3 and we go to 5, I mean, as much as I agree with you, you'd say,
Right.
why did we go to 5 if everybody else gets 3?
Consistency.
And honestly,
Consistency.
if it's somebody who doesn't come regularly and they've got something to say and they've almost finished their point, I don't tell them to sit down at 3.
And that's your
There's
discretion, and
discretion.
that's used
Yeah,
as applicable.
Yep.
I agree with all that.
So,
Is the consensus 3, 5, and 5? 3, 5,
3,
and
5,
10?
10?
5, 10?
I think 3, 5, 10.
Is that consistent with other boards that I'm not, is it?
Honestly, others don't always
3
limit
is.
it. 3 is consistent, yeah, but nobody else times on the second and the third like we
Copy
do.
that? Gotcha.
how about 355 with the request of the board to extend?
I like that
Do
even
you
better.
want to
Keeps
just
it
have it
moving.
automatic?
That even better.
Keeps it moving.
Like
Thank
I
you.
said,
Right.
I want to get these meetings going.
Yeah.
Yeah, at least let them.
shorter, fine, I don't care.
So
If
you
they-
can
if they
always
know they
suspend
need-
your rules. I'm sorry, I didn't mean to
Allow
interrupt
more,
you.
so yeah,
Yeah.
355 with an extension.
Yeah, if the board votes to
I
do
like
that.
that.
Board can vote to extend time.
Perfect.
But the applicant would have to request that, right?
Yes.
Yeah,
So they're
May
at
I
4.
continue?
The speaker.
Well, that's what I meant, the person speaking, okay. So are we good with our next draft to come back? Did anybody have anything else?
Everyone else.
Yes.
Mr. Chair, on 3H, about you are responsible to review, receive, and refer appropriate questions from the planning board staff. Is that consistent throughout the city? Does the same rule apply to the ZBA and the HDC and Concom?
I don't know.
I know for the zoning board it does.
Right. I think for most boards and even the city council, the requests for staff go through the city manager
Yeah.
from the city council. The votes, requests for the other boards go through the chairman of the board to go to the staff so that the staff is not inundated with, independent.
So how's that work? If I had a question for Peter, if I can't talk to him in the hallway, I can't give him a call. There's no communication between Peter and myself on any planning board issue?
That's the way it's worded, right. But that's why we're here, to talk about these kind of things.
All right. I just have one other request for the next round. If we could get any edits, 7 days or some other reasonable time instead of 7 seconds before the meeting, I'd appreciate that.
And a follow-on comment, because at the beginning of this, we were talking about trying not to overburden the chair with having to approve every agenda. But now we're talking about overburdening the chair to have all of our communications go through you, and I frankly disagree with that. I mean, you're a volunteer, you're a professional. There are instances of questions that we could ask Peter that might be this big. And it takes your bandwidth as a practicing professional to not to mention the whole telephone thing. Asking me a question to the person who has the answer in city documentation, the game of telephone, how many times you ask the question, how many times the answer comes back wrong. I mean, if I would ask Peter something that I pulled out of a rule, regulation, whatever, I feel that you would get a more accurate answer going to the source. I mean,
I understand the point. I think, and
this is out of respect for you.
I appreciate
you're
the
working hard.
concerns about my bandwidth and all that. I think it's part of the job. And honestly, I try to take requests from both sides, both from staff and from
Point
the
taken.
planning board. And this has been a repeated request, and I think it's just one of the responsibilities.
I also think that sometimes if there's multiple board members that are all asking the same question, this gives the chair the opportunity, because I know sometimes we'll ask a question of the city manager and she purposely emails the answer to all of us, knowing that some of the rest of us might have that question as well. So it kind of works the same way, and it makes it a little bit more succinct, so going through one person.
Are we suggesting that these questions are going to be considered by you and filtered as to whether or not they're serious questions or if they're excessive questions, or are you simply passing through every single question that's
I
asked?
changed it to appropriate questions.
Okay.
So, I mean, there are times, most people, I won't say we all do it, but sometimes a late night comment comes through that maybe might not come through at 10 in the morning. Just saying. So, yes, Bill.
Is there a difference between content questions and process questions? As a new guy, I've got process questions that I have been kind of reluctant to ask anybody, but is it appropriate to be asking Peter process questions?
Now that you've been appointed, you're supposed to come through the chair. So, and don't be afraid to ask questions. Questions are good. That's how we all learn. So, fire away. And there may be instances where we want to talk about something at a meeting, and maybe it's going to be more than Peter. Maybe the other Peter, or maybe some other staff people will come as well to discuss something if the board wants to discuss it. But, like I said, it's been a request. I've tried to honor it, and I don't think it's problematic, honestly. But, I mean, it's a little bit more of my time, but so what? We good? Did you have anything else, Susan?
No, I don't think so.
Nothing further.
Okay.
Motion to adjourn?
So,
We're
second.
adjourned. I'm just adjourning it. Thank you.